Welcome to VLearn Virtual Learning Network. This is session number 11 and this is part 2 of Mercantile Law, and the topic is Companies Act 1956. Topics to be covered are doctrine of constructive notice, exceptions of indoor management, prospectus, what constitute invitation to public, misstatement in a prospectus and its consequences, share and share capital, kinds of share, allotment of shares, power which are exercisable only by the shareholders, powers, and last one is qualification and disqualification of directors. Now come to the first topic, that is doctrine of constructive notice. According to section 610, every person dealing with the company is deemed to have read MA, that is Memorandum of Association, and AA, that is Article of Association, and understood the contents thereof in the correct perspective. Doctrine of indoor management. The rule was first laid down in Royal British Bank. Rule of indoor management is an exception to the doctrine of constructive notice. Exceptions of indoor management. First is knowledge of irregularity. There is also a case of knowledge of irregularity, that is Howard versus Patent. Second, negligence case, Anand Behari Lal versus Dinshaw and Company, that is Bankers Limited. Forgery case, that is Reuben versus Great Fingal Consolidated. No knowledge of article case, Rama Corporation versus Proved Tin and General Investment Company. Now come to the prospectus. What is prospectus? A prospectus as per section 236 means any document described or issued as prospectus and includes any notice, circular, advertisement or other document inviting deposits from the public or inviting offers from the public for the subscription or purchase of any shares or debentures of a body corporate. Thus, a prospectus is not merely an advertisement, it may be a circular or even a notice. A document shall be called a prospectus if it satisfies two things. डॉक्यूमेंट प्रोस्पेक्टस कह सकते हैं आप डॉक्यूमेंट को अगर वो ये दो कंडीशन सेटिस्फाई करता है. पहली कंडीशन, it invites subscription to shares or debentures or inviting deposit. Second, to aforesaid invitation is made to the public. What constitutes invitation to public? As per section 67, invitation to public includes invitation to any section of the public, howsoever selected, provided the invitation is made to all the members of that section of public indiscriminately. Invitation calculated to be made available even to those who do not receive the same, and invitation to 50 or more persons. Misstatement in a prospectus and its consequences. Now, what is misstatement? According to section 65 first of the Act, a statement included in a prospectus shall be deemed to be untrue if the statement is misleading in the form and context in which it is included. Second, where the omission from a prospectus of any matter is calculated to be mislead, the prospectus shall be deemed in respect of such omission to be a prospectus in which an untrue statement is included. There is also a case of this misstatement, that is Rex versus Kylstein. Next is share and share capital. According to section 246, a share represents a unit into which capital of a company is divided. However, courts have held that a share is not merely a unit of capital. It represents a bundle of rights and obligations. Holder of a share is entitled to certain rights, that is, right to receive dividend, receive notice of meetings, to participate in proceeding of a meeting, to elect directors, and is also subjected to a number of obligations. Say, to abide by Article of Association, to maintain decorum of the meetings. Kinds of shares. The following kinds of shares may be issued by the company: First, equity shares carrying voting rights. Second, equity shares which carry differential right as to voting or dividend, that is commonly called non-voting equity shares. Third, preference shares, and fourth one is cumulative convertible preference shares. प्रेफरेंस शेयर्स कैरी प्रेफरेंस विद रिस्पेक्ट ऑफ टू थिंग्स. जो प्रेफरेंस शेयर्स होते हैं वो प्रेफरेंस कैरी करते हैं टू थिंग्स, दो केसेस में. प्रेफरेंस शेयर्स विद रिस्पेक्ट टू डिविडेंड एट अ फिक्स्ड रेट और a fixed amount. Second, preference with respect to return of capital in case of winding up. Equity shares means a share which is not a preference share. That is, allotment is an acceptance to an offer for purchase of shares. Where allotment does not conform to the statutory requirements, it is called irregular allotment. For allotment to be valid, following requirements must be satisfied. A copy of prospectus and statement in lieu of prospectus must have been delivered to registrar of companies. Second, application money must not be less than 5% of the normal value. Third, minimum subscription, that is at least 90% of the issue must have been received. Fourth, application money must be kept deposited in a scheduled bank till the minimum subscription has been received. Shares must have been listed on the stock exchange mentioned in the prospectus. Administration management of a company. A company functions through a medium of board of directors. However, certain powers have been reserved to be exercised by shareholders in general body meetings. Section 291 of the Companies Act 1956 confers general power on the board of directors. It provides, subject to the provisions of the Act, the board of directors of a company shall be entitled to exercise all such powers and do all such acts and things as the company is authorized to exercise and do. Powers which are exercisable only by the shareholders: sell, lease or otherwise dispose of the whole, substantially the whole, of the undertaking of the company, or where the company owns more than one undertaking of the whole or substantially the whole of such any such undertaking. Remit or give time for a repayment of any debt due by the director except in the case of renewal or of continuance of an advance made by a banking company to its director in the ordinary course of business. Powers: invest otherwise than in trust securities the amount of compensation received by the company in respect of compulsory acquisition of any property or fixed asset of the company. Fourth, borrow monies exceeding the aggregate of the paid up capital of the company and its free reserves. Borrowing does not include temporary loan, that is loans payable on demand or within 6 months, but excluding loans for capital expenditure obtained from the company's bankers in the ordinary course of business. The resolution passed at the general meeting must specify the total amount up to which money may be borrowed by the board of directors in any financial year. Fifth, contribute in any year to charitable and other funds not directly relating to the business of the company or the welfare of its employees any amount exceeding rupees 50,000 or 5% of its advantage net profit of the last 3 financial years, whichever is higher. However, the resolution must specify the total amount that may be contributed by the board of directors in any financial year. Contribution of national defense funds, the Prime Minister's national relief funds or any other funds approved by the central government for the purpose of exempted from the above provisions. Qualification and disqualification for directors. First is qualification. A public company cannot prescribe any qualification for directorship except the share qualification. Again, share qualification requirement cannot exceed holding of shares exceeding rupees 5,000 in nominal value or value of one share where nominal value of one share exceeds rupees 5,000. A director may obtain his Share qualification within 2 months after his appointment. Section 274 of the Companies Act 1956 provides that the following persons shall not be capable of being appointed as directors of any company. A person found by a competent court to be of unsound mind and such finding remains in force. B. An undischarged insolvent. C. A person who has applied to be adjured and insolvent. A person who has been convicted by the government of an offence involving moral turpitude and sentenced in respect thereof to imprisonment for not less than 6 months and a period of 5 years has not elapsed from the date of expiry of the sentence. A person who has not paid any call in respect of shares of the company held by him, whatever alone or jointly with others, and 6 months have elapsed from the last date fixed for the payment of the call, and a person who is already a director of a public company which has not filled the annual account and annual return for any continuous 3 financial years commencing on and after the first day of April 1999, or has failed to repay its deposit or interest thereon on due date of redeemed its debentures on due date or pay dividends, and such failure continues for 1 year and more. Number of directorship. Whole-time directorship. A person cannot be appointed as a whole-time director in more than one company. Part-time directorship. Not more than 15 companies excluding the directorship of. Number of directorship. Private companies other than subsidiaries or holding companies of a private companies, unlimited companies, association not carrying on business for profit of or which prohibit payment of a dividend, and alternate directorship, that is, he is appointed to act as a director only during the absence of incapacity of some other directors. Now there are some questions on the basis of this session. First one is, what do you mean by disqualification and what are different kinds of share? Thank you. Happy learning. We learning.